Hi, welcome to Ask Tim, the insurance technical podcast brought to you by IABNY. I'm your host, Tim Dodge, and I'm coming to you today from the palatial Grand Ballroom here in the East Wing of IABNY headquarters in lovely DeWitt, New York. All right, actually, it's just the meeting room where we have our continuing education classes, but work with me here. I also have the honor today of recording this podcast in front of a live studio audience. We have the students here from the InVEST program from some high schools just a little bit south of here, so I want to welcome everybody. It's really early in the morning here on the East Coast, so just for the heck of it, I'm going to see how good their reflexes are.
Ow. Ow.
Ow. Ow. Ow. Ow. Ow. No, I didn't think it would bounce that much. Not to worry, though, because their parents all signed liability waivers, so there's no way I can be sued. And plus, there's an urgent care facility just 10 minutes from here, so it's all good. So if you'll kindly refrain from bleeding all over the carpet, we'll get on to today's main topic, which is auto insurance and Facebook. Now, a lot of auto accidents are pretty minor affairs. They're little fender benders, somebody rear-ends somebody at a stop sign, no serious injuries. Maybe some stitches, things like that. Fortunately, a lot of accidents are like that, but some are more serious. Somebody ends up being hospitalized, having to have surgery, physical therapy, something like that. Now, when insurance companies are given those bills, they're going to have to write big checks. And when they're asked to write big checks, they're going to use every tool that they have to find out whether or not that claim is legitimate. Exhibit A is a court case that was decided here in the state of New York by a New York appeals court in November 2010 under the name of McCann versus Harleysville Insurance Company of New York. Now, Kara McCann was seriously injured while driving her car when another driver struck her vehicle. And that driver was insured by Harleysville Insurance Company. Now, the other driver's liability insurance paid her a fair sum of money for her injuries, but it wasn't enough to fully compensate her. So she made a claim to Harleysville for supplemental uninsured, underinsured motorist benefits. Now, for the students here watching, supplemental uninsured, underinsured motorist coverage, that covers you if you're injured by somebody else and they don't have enough insurance or they don't have any insurance to pay for your injuries. So she made a claim to Harleysville for these benefits. Now, anytime somebody has to go into this particular coverage, they've racked up some serious bills. We're talking tens of thousands, possibly hundreds of thousands of dollars in medical expenses and associated injury awards, pain and suffering, that sort of thing. So Harleysville apparently was not altogether convinced that Ms. McCann was as seriously injured as she claimed she was. And so they demanded certain information from her. Specifically, they demanded photographs, and they wanted authorization for her Facebook account. They wanted to be able to go in and view her Facebook account. She refused to give them that access. They said, then we're not going to pay your claim, and it went to court. Lawsuits ensued. It went to a trial court. The trial court said that the insurance company's demand was too broad. And so Harleysville appealed. They took it to the appeals court in New York. And the appeals court said that Harleysville had failed to produce any factual basis for the belief that there might be anything relevant in these photos or in the Facebook account. In fact, the court said that Harleysville appeared to be on a fishing expedition into her online information based on the mere hope of finding relevant evidence. Essentially, they were saying the company is saying, we don't know whether we're going to find pictures of her dancing or not, but it's worth a shot. And the court said, that's not enough. You have to have some factual basis for thinking that what the information on Facebook or in those photos is relevant. They did say that if the company later came up with some factual basis for believing that, reports, interviews with their friends, or anything like that, then they could go back to the court and ask for permission to look at her Facebook account. So what are the lessons that we can take from this story? Number one, on liability insurance. Liability insurance pays money that you owe to somebody else because you've injured them or damaged their property with your car. The state of New York sets minimum amounts of insurance that you have to buy, liability insurance that you have to buy. Buying those minimum limits, really bad idea, because as what happened in this case, and I don't know whether the driver who hit Kara McCann had the minimum limits or not, but apparently that amount of insurance got used up, and it was not enough to compensate her. So one lesson is that buy as much liability insurance as you can afford, because you want to have enough to protect you if you get sued because you hurt somebody with your car. And even though this other uninsured motorist coverage is available, the insurance company still might try and come back and get their money back from you. So buy as much liability insurance as you can afford. That's lesson number one. Lesson number two, it's always a good idea to consider buying this supplemental uninsured, underinsured motorist coverage. Again, that protects you if the person who hurts you has no insurance or doesn't have enough insurance, or if they hit you and leave the scene of the accident, take off and you never find them again. Things like that happen. So this is a very valuable coverage to have. It's not all that expensive because fortunately severe accidents like that are relatively rare. So you want to consider buying as much of that as you can afford. Lesson number three. In this particular case, the insurance company lost. They wanted to get access to her Facebook account and the court said no. But the court said if you had done it right, you could have gotten that. If they had come up with a good reason, the court said we could have forced her to give up her Facebook password. So keep in mind that anything you put on social media, Facebook, Twitter, Google+, whatever, Instagram, Pinterest, whatever, that's out there for the whole world to see, and it could be used against you in court when there's a dispute like this. So be aware of what you're putting on Facebook, and just keep in mind that if you make a large claim to an insurance company, they can and probably will attempt to get access to that information. If you want to get in touch with me, you can email me at tdodge@iabney.org. You can call me at 800-851-8853, extension 229. You can find me on Twitter as Ask Tim. You can send me a fax at 888-432-0510. And if you see me out and about at an IABNE event or at a class that I'm teaching, I always welcome your questions there as well. Thank you for watching this episode of Ask Tim. We'll be back soon with another episode. And remember, if you ever want to wake or startle or simply annoy a group of high school students, don't forget to Ask Tim.